Hello, American legal systems. It's Miss Anderson again. Okay, so you know what's gonna happen here. We're gonna do a little video lecture. Oh, and hi, Mr. Vorlander. Thank you for being such an amazing sub that all my students really love. And they had a great time on Monday and said you were awesome and chimed in. And that's awesome. I mean, that's kind of ideally what I would hope happens, is that you guys can listen to me talk, and then Mr. Vorlander can chime in with, topics, events, things like that he knows. And yeah, and we'll just kind of try to keep going. The other thing I want to say too, so right now it's after school on Wednesday. You guys will be seeing this on Friday. And right? Yeah, that's right. So you guys will be seeing this on Friday. I am going to, between today and Friday, I'm going to be doing your video conference, your paper video conferences. So I'm going to be creating videos of me talking through each of your papers. I'm hoping it goes well. Cross your fingers. If you have any questions, if you get your video and you're still confused about what I meant, or you're not really, even if you're just upset or you're confused, just come and see me. I'll be here all day on Thursday, although you're seeing this Friday. You can email me. So whatever the case, just make sure you're in touch with me. Don't feel like you can't talk to me about it. Okay? All right. So good. Okay. Well, I'm also hoping that this particular video can be in one segment. I'm going to try to upload it in one solid segment, although I'm a little nervous to do that because I'm afraid YouTube is going to freak out and not let me do it. So I'm crossing my fingers that we can do this all in one long segment. If there are times when I want you to stop and talk about things, I'll let you know that as we go. Okay? Good. Okay, so we talked about double jeopardy, like exclusively double jeopardy and double jeopardy exceptions in class on Wednesday. So today we're going to continue talking about Fifth Amendment issues, and we're going to talk about the next thing in line in the Fifth Amendment. So get out your Bill of Rights books. Get out your little books that have the Bill of Rights in them. I shall get out my very much loved mini pocket Constitution, and I will begin reading by saying the following. No person shall be held to answer for a capital or otherwise infamous crime unless on presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself. Okay, so the witness against himself is the next big component. So what does that mean? When you hear people talk about the Fifth Amendment, I said this in my earlier lecture on that you guys saw on Monday. When people say the Fifth Amendment, what do they say? Like, what do they reference? I hope that as I'm pausing, you are giving answers, maybe. Okay. People typically are talking about things like pleading the Fifth. So raise your hand and look around at each other. If anybody has ever heard somebody say, I'm pleading the Fifth on that one. I'm pleading the Fifth. I'm going to take the Fifth on that. Like in casual conversation, sometimes people will say that. And they're representing, or actually they're referencing this very specific section of the Fifth Amendment. That no one, just going to say it one more time, that nor shall be compelled in any criminal case to be a witness against himself. So remember the Star Chamber? Go back, think back. I know nobody remembered defamation, which was a little bit of a blow. I'm not gonna lie, that was a little blow yesterday when nobody or the other day when nobody remembered what defamation was. I really hope, Taylor Hewitt, you looked that up to find out what defamation was, because you should absolutely know what it is, since I spent 45 minutes talking about it in class. But go back even further to the Star Chamber. Remember the Star Chamber? Remember that awful time in English history when the king was really abusing people, in particular people who were speaking out against the king. It was when the king was sort of battling with Parliament over, whether the king was going to have all the power or Parliament was going to have some of the power. Okay. Well, one of the things that happened under the Star Chamber was that people were forced to give testimony. So they would be called before the Star Chamber, the judges of the Star Chamber, and they would be required to answer questions. On its face, that doesn't seem like such a big deal. All right, whatever. But the reason it's in here is because under the Star Chamber, that particular practice became so obviously onerous to people who were being accused. That particular practice was, in fact, something that was very infamously used to essentially twist people's words. Let me say it this way. I wonder how many of you out there have a little brother or sister. I know Peter does. Hi, Peter. Talking to you again, Peter. All right. Little brothers and sisters, right? Think about your little brothers and sisters. And think about if your little brothers and sisters have ever done anything that you, stole something from you, took something out of your room. Now, I say this because I speak from experience as a younger sister who has, in fact, and did, in fact, on a number of occasions, steal things from my sister's bedrooms. To be fair, they were really awesome things that any little sister would covet, like, say, for example, a Thriller tape. Sorry to my sister, Dewey. I took your Thriller tape. Or probably the worst thing I ever did to my sister Dewey. My sister Dewey, I think I've told you, her name's Deweyna. We call her Dewey. It's a family name. Okay, so my sister Dewey, she got like a corsage from her boyfriend for prom, right? She was 5 years older than me, so she was 16. I was 11. I didn't think it would be a big deal if I took that. Why would she want a bunch of dead flowers, right? It was a pretty big deal. If you've ever been a 16-year-old girl and gotten a thing of flowers from your boyfriend, you tried to dry them in your bedroom. Okay, my sister Dewey was devastated when she found out that I had pulled every petal off of her roses and scattered them about in my Barbie house, but okay, I digress. That's another story. The reason that I am bringing this very particular story up and asking you to consider your younger brothers and sisters that are out there is because I wonder how many of you have ever looked at your brother and sister and said, "Look me in the eye. Are you lying to me? You better not be lying to me," right? Or asked a question like, so I know you stole all of the cookies off the plate in the kitchen. I know you did. No, I swear I didn't. Then tell me this. How many of you have ever interrogated a little brother and sister, right? You can pretty much, correct me if I'm wrong, if you're smart enough, and most of you are smart enough, you can pretty much get them to say whatever you want them to say, right? I mean, if you're talking to a 7-year-old, you can kind of twist their words. You can get them confused enough on occasion that you can get them to say whatever you want them to say, right? Well, the principle that applies here, and the reason I'm bringing this up, is because in a court, it's very similar. And in the Star Chamber, similar kinds of things happened. People would be brought before the court, and even though they were being asked things and asked questions that on their face you would think they would be able to simply just sort of deny it or talk their way out of it, a really skilled questioner can get people to admit things or can twist people's words when they don't really even mean to. and the person doesn't even wouldn't necessarily want to give that information away. A case that you guys are aware of is, of course, the case of Brenton Butler from the film Murder on a Sunday Morning. I mean, how do you get a person to literally admit and sign a document that says that they killed someone when they didn't actually kill someone? I mean, it's one of the things that convinces juries that confessions are perfect and total proof, right? Even though we all know that they aren't, and we've learned in here that they aren't. One of the things that convinces juries that they're such trustworthy sources is that who would say something that wasn't true that incriminates themselves? Well, in the Star Chamber, this happened all the time. Skillful questioners asking questions that were leading, that led people down a certain path, that twisted people's words, that said, oh, what you really meant by that was this, wasn't it? I mean, if you've ever had someone, for example, you know, I'm going to be honest, I consider myself to be pretty good at busting kids, in particular when I'm busting them for things like cheating. And I've told you guys stories about this before, you know, kind of just approaching a kid and saying like, all right, so you gonna tell me what happened here? Like, really all you need to do is start with that question. And a lot of times people will just sort of spill their guts. What Madison and the framers of our Constitution did was they used the history lesson that the Star Chamber was to design a rule that would say people can't be forced to sit on a witness stand and to give testimony that might incriminate them, because they considered that to be such an unfair situation. And again, I'm going to force you guys to think about those scales, right? Wanting to ensure that those lawyers who are, you know, very gifted and good at questioning, who've been down this road before, sometimes who may have more information than you have, wanting to ensure that those particular individuals do not tip those scales so out of whack that the accused actually end up giving testimony against themselves, which, as we saw in the Brenton Butler case, ultimately by a jury ends up looking like evidence that's much, much more influential than almost any other kind of evidence. So not only do you have a situation where people are having, in a mythical situation or a historical situation like happened in the Star Chamber, where people are forced to testify against themselves, it's really a twofold problem for those people, because not only are they up against questioners that can twist their words and make them say things that they might not actually mean, but you also have the listener or the jury or the judge deeming that particular testimony, because it's coming from the accused themselves, deeming that testimony to be more influential. So your right not to testify against yourself is critical. And it's been really famously used by a lot of people. I think probably one of the most famous cases in my lifetime that I think of is Ronald Reagan pled the Fifth. There was an incident in the 1980s called the Iran-Contra scandal. Now, at this point, I'm going to invite Mr. Warlander at any point to chime in, because he also lived through the Iran-Contra scandal. And I was a kid when it was happening. I was like in, like upper elementary school, middle school, I think is how old I was when all this was happening. So I have kind of a kid's memory of it, but Mr. Warlander was an adult, so he probably can correct me if I have anything if I'm in error. But essentially what was happening was that the Reagan administration was funding the sale of weapons to Iran, and was, you know, using pilots to actually deliver those weapons. And it was all very scandalous because the United States had a terrible relationship with Iran. Iran had held hostages, American hostages, in Tehran in 1979 for, God, I don't even know how long, for over a year they were held hostage. It was a huge international deal. The Reagan administration had very famously busted these people out of their, they negotiated them out of their hostage situation. That's a whole nother story of Reagan thwarting the Carter administration and their attempts to get him out. It's kind of all fascinating history. So, but we had this bad relationship with Iran, and it turned out we were selling weapons to Iran, and we were using the money that we made selling those weapons to fund the Contra rebels who were trying to overthrow a democratically elected government in Nicaragua. Okay, so it's a complicated story, but it's fascinating. And so it's called the Iran-Contra scandal. Well, when the whole, mess hit the papers and everybody was up in arms about it, the federal government was investigating. The Justice Department in the United States government is the organization. It's the sort of law enforcement branch of the federal government. The Justice Department was trying to gather information, and they were actually had people testifying. Well, they wanted to know if President Reagan was aware that this stuff was going on. So they actually put him on the stand and asked him to testify. And the President of the United States got on the witness stand and pled the fifth, said, I am going to use my Fifth Amendment rights, so people assert their Fifth Amendment right not to act as a witness against themselves on the stand. And you can assert that right at any point. However, if the courts do not deem the testimony that you are potentially going to give as potentially being damaging to you, then you can't assert your Fifth Amendment rights in that case. So for example, if you're being subpoenaed, so a subpoena is a request by the court, it's actually a demand by the court, it's a lawful demand, that you have to testify in court. So let's say, for example, that, of course, I don't know if I should pick on Peter or not, because I did last time, but let's go for it. Peter, you up for it? Okay, let's say that Peter is being called to the witness stand, okay? And Peter is being asked to testify at a murder trial. And let's say that Taylor is on trial. It's a refreshing change of pace. Make Taylor the murderer in this scenario, okay? So Taylor is being charged with murder, okay? And what they're saying is that Taylor murdered a person because of drunk driving. So he was driving his car, driving down the road, and was, hit somebody and killed them. So this is his trial. So they're calling Peter to the stand to testify because Peter was at the party where Taylor was prior to Taylor getting in his car. So he left a party that Peter was at, okay? So Peter comes to the witness stand, and the prosecuting attorney says, did you witness Taylor Hewitt drinking any alcohol at this party? At this point, Peter could potentially be considered, he could think to himself, okay, am I going to incriminate myself? If I say, yes, I saw Taylor drinking alcohol at this party, does that necessarily incriminate me? You could see a scenario where it would, right? I mean, maybe you didn't report the crime. It was a crime that you saw happening, somebody drinking underage, you didn't report it. Could that potentially be considered you incriminating yourself then? Admitting that you saw a crime or that you did a crime by not reporting the drinking. So you could plead the fifth. However, what would very likely happen is that the prosecuting attorney would give you what's called immunity. He would give you testimonial immunity. And he could, at that moment, he could say, Your Honor, at this point we would like to, we're stating that we're going to give immunity, testimonial immunity for this charge, for the charge of not reporting seeing someone drinking alcohol. An underage drinker, that is, not reporting an underage drinking party. If the judge accepts that, then You no longer have the threat of that charge hanging over your head. Therefore, you would have to testify. Now, what if it was something more serious? What if the police were asking you, or the prosecutor was asking you, were you drinking at that party? Well, that's a more serious charge, right? I mean, again, you would be admitting guilt, testifying essentially against yourself. You would be reading into the record, admitting guilt. And the record of a legal proceeding is a legal document that could be used against you later. So if you admit to committing a crime, so if Peter says, yes, I was underage drinking, Peter could be charged by the prosecutor later for that crime, and evidence of that crime could be his testimony in that court that day. But again, the prosecutor would likely give you immunity. In that case, the Fifth Amendment no longer attaches. You no longer have the right to plead the Fifth, as they say. Does that make sense? Take a second. The scenario in a different, if we take the same scenario and we talk about it slightly differently. So if Taylor is being called to the witness stand, and let's say, for example, the prosecutor calls Taylor to the witness stand. So Taylor is the one being charged, and they put Taylor on the witness stand. Taylor can, at any point, he can say, I'm not going to testify. He does not have to testify. In a case like that, when you are being prosecuted, you would, under almost no circumstances, would you ever be put on the witness stand by a prosecuting attorney. And the reason is because you're going to just plead the Fifth. I mean, there's no point in them putting you up there, because anything that prosecutor asks, he could say, I'm not going to talk about that because obviously that's relevant to this conviction or this prosecution. Otherwise, they wouldn't be asking it. And they're not going to give Taylor immunity, not if this is the case that they're pursuing is against him. So it doesn't work the same way with the individual who's actually being charged. Okay? Now, to take it to sort of the next level. So in a court case, what typically happens is the prosecutor presents their case. And when we go to the courthouse, you guys will see examples of this. So the prosecutor presents their case, but then the defendant has the opportunity to present their case. At that point, the defense attorney and the defendant themselves could make the decision to put the defendant on the witness stand. So Taylor could decide. So once the prosecutor is done with their case and they've, had their whole presentation of evidence and all their witnesses have come up and testified, then the defense has an opportunity to call witnesses. If Taylor voluntarily gets on the witness stand and, decides that he is going to testify, then he is opening himself up to questioning. He is not being forced to testify against himself. He's not being compelled, is the word that they would use in sort of legal jargon. He's not being compelled to testify against himself. Rather, he is choosing to testify, and therefore the Fifth Amendment immunity against testimony would not attach in that case. Okay? So if Taylor chooses, then it doesn't attach. Now, there's kind of a little saying that lawyers have, that only a guilty man voluntarily gets up on the witness stand. And it's a rule of thumb that I learned a long time ago at one point. It's sort of a thing that lawyers say. And I wonder if you guys can figure out why a lawyer would say that. Like, what is it about this decision to go up on the witness stand that might lead lawyers to say, Guilty people are the ones who want to testify. Only a guilty man would get on the witness stand to testify. Innocent people don't testify. I wonder if you guys can think about that for a second. It's kind of I don't know if it would be something you would naturally, a conclusion you would naturally draw. The rationale is, or sort of the reasoning, and the reason that they say this is because, guilty people tend to feel defensive. Guilty people often feel the need to defend themselves, to keep going, to talk, try to talk their way out of it. Innocent people tend to trust the truth more and to trust the system more. So they tend to be more willing to not testify. The next question I have for you guys is, why would someone not testify? Like if you were Taylor and it wasn't you in that car that night, like why wouldn't you get on the witness stand? Aside from what I just said about innocent people tending to feel more willing to trust the system and more willing to trust the truth, there's sort of another component to this. The reason why attorneys do not recommend that their clients, the accused, go on the witness stand is because when you put yourself on the witness stand, you put yourself at the mercy of oftentimes the very smart, very clever, and experienced cross-examinations and cross-examining attorneys. I don't know if any of you have ever been cross-examined in a courtroom. I would suspect most of you haven't. I hope most of you haven't. But if any of you have ever been grilled by someone who is really good at getting people to, say what they want, I don't want to brag or anything, but I do consider myself to be, it sounds really braggadocious to say this, but, maybe it's because I'm always trying to get the truth out of, 16-year-olds, so it makes me feel like I'm good at it. I don't know if I could do it with adults as much as I do it with teenagers, but, if you ask the right questions, you can get people to say things that they might not want to say. So let me see if I can do this on the fly. I actually haven't planned this out, so I might completely look like a total dummy trying to do this. So if I'm asking, and it might be kind of difficult because I'm not going to get any responses from anyone in the room, so I'll do my best. So let's just say that I am, let's say that I suspect that Sam was, oh gosh. If the charge against Sam is that she, I don't know. I'm going to try this. That she was cheating. Let's just go with that, since that's something that I deal with fairly frequently. I could start my questioning with, now Sam, you were in my American Legal Systems class, right? So you should answer, Sam. So the answer is yes, right? And you were given an assignment to write a paper. Isn't that also correct? And that paper that you wrote came back with some marks on it, didn't it? And those marks were written by me, the teacher, weren't they? And those marks actually indicated that the information that you wrote in your paper was the exact same information that was written on Ashley's paper. Isn't that also correct? Now, Sam, the information that you wrote in your paper, that was the exact same information that was written on Ashley's paper, was actually information that both of you copied from a web page, wasn't it? I mean, like all these really direct questions where I am essentially I'm testifying, I'm stating, here are all the things that I know. Now, it might not be true. It might not be true that she copied off of Ashley. It might not be true that she even took that information from the internet. But to a jury, I have essentially just stated all that to them. I've just said, isn't this all true? This is all true, isn't it? And even if she says no, at certain points, it doesn't really matter. And so as a defendant, you have to be really careful. And again, this is one of the reasons why this self-incrimination portion of the amendment exists. Now, there's a whole nother branch of this self-incrimination clause of the Fifth Amendment. We've been talking about the Fifth Amendment as it's applied in the courtroom, but there's another area in which self-incrimination is applied, and it is applied in the streets, in police work. And the very famous case, the one that you guys have, almost all of you have heard, is, I wonder if I pause here, if anybody can tell me the most famous self-incrimination case. Anybody? Okay. Did anybody say Miranda? Did anybody say Miranda v. Arizona? I'm really sure Mr. Deaton goes over this in GSI. And if you did, give yourself a little pat on the back. You're a pretty special fellow or gal. If you didn't, it's okay. Now you know. It's Miranda v. Arizona, and the case comes out of 1966. So again, I would like to harken back to what I told you the other day. Whose court was it in 66? That's right, it was the Warren Court. I know you all said it in unison, right? Okay, Chief Justice Earl Warren's court in 1966 laid down another landmark ruling that established the civil liberties of criminal defendants. And he did it, or they did it, in the Miranda case. So the case is called Miranda v. Arizona, and the date is 1966. Now, in this particular incident, the gentleman Miranda is who we're talking, his last name was Miranda, was being arrested for possession of marijuana. So he's in Arizona, arrested for possession of marijuana. He was handcuffed, and he was put in the back of a police car. As the police were driving him to the police station, they began asking him questions about some rapes that had occurred in the area. And they wondered if Miranda was the guy. They start asking Miranda some questions. Miranda, confused about what he claimed confused about what the police officer said, and confused about why he was being asked these questions, and also unaware of his right to remain silent or his right not to incriminate himself, began making incriminating statements that led the police to believe that he had actually committed this series of rapes in Arizona. He was then charged, and his statements that he made to the police on his way to the jail that night were used at trial, and those statements were actually part of what convicted him of those rapes. He appealed that decision, and his lawyers at the Supreme Court, once it went all the way up to the Supreme Court, claimed that by using Miranda's own statements at court as part of the evidence against him, they essentially made him a witness against himself, that he had unknowingly, and that's important, that he had unknowingly testified against himself, because literally those statements became part of the testimony at trial. So what the court decided, as you all well know, is that cops can't do this. They can't ask you those kinds of questions and use those statements at trial unless you are aware that you have the right to waive that right. And this is the same with anything else. If you allow the cops into your house, you're waiving your right to force the cops to get a warrant. If if you allow the police to give you a breathalyzer, you're waiving your right to require the police to get a warrant for that search. If the police know that you are aware that you have the right to remain silent, but you speak anyway, you are therefore waiving your right. Okay, you're saying, I don't care, I'm going to tell you this anyway. Okay, so what the police essentially had to do after Miranda is they had to read something that very famously came to be called what? I really hope you said your Miranda rights or the Miranda warning or read you the Miranda. Miranda, for the rest of his life, he's named after this thing, right? And where do you always see the Miranda warning? I mean, how do we all learn the Miranda warning? It's kind of a marker of modern society that we don't learn it in school. Where do we learn it? Yep, on TV. That's where you guys learn them. That's where you learn the Miranda warning. All right. Without people to stop me and ask questions, I guess my voice doesn't get a break. Okay. So, can you say it? I'm going to pause for a second. And I wonder if you guys can say the Miranda warning. Go. Did you do it? Could you do it? Okay. Did you say, you have the right to remain silent? Anything you say or do will be held against you in a court of law. You have the right to an attorney. If you cannot afford an attorney, one will be appointed for you. Do you understand these rights as they have been read to you? Did everybody say that? Or did you say some sort of part of that? If you didn't say it out loud, because you're all so shy and you probably felt like you didn't really want to say it, if you didn't say it, then you might have been thinking it. And you've probably heard it on every CSI, Law and Order, whatever kind of cop show movie you've ever seen. And that's called the Miranda warning. Now, here's the thing. What it does is it informs people to remain silent, and it also reminds people of their right to counsel, which is added in there. It's intended to invent abusive police practices and essentially police taking information from people without their knowledge of their rights. Now, here's the thing, and a lot of people think that it's the law. I've had actually kids say things to me like, "Oh, well, they don't have to say that to you if, or no, scratch that. Back up a second. They didn't read my Miranda warning." Sometimes people will say this. They didn't read me my Miranda warning, so the stuff that I said, they couldn't use it because they didn't tell me what my rights were. And that actually is not true anymore. Because of the fact, what the courts have recently decided is because of the fact that just a second ago when I paused and waited for you guys to say the Miranda warning, even though right now it's about 48 hours before you're actually going to say any of that stuff. So you said it like 48 hours after I predicted you would be able to say it. I could predict with pretty clear accuracy that at least most of you would be able to almost word for word say that Miranda warning. Because of that very fact, the courts have said the Miranda warning is so ubiquitous, it is so well known that in fact police are not obligated to read it to you any longer. And in fact, they do not have to read those rights immediately upon arrest, only prior to questioning. So if police are going to, if they're basically just transporting you, most of the statements that you make in that transport, even if they don't read your Miranda rights, police have successfully argued that people know these rights. He should have known that he didn't have to say these things. And I hate to tell you all this, but if you are ever in a situation where you're arrested The police ask you a bunch of questions. You make a bunch of statements. They use those statements in court. The fact that you took this class could be evidence that the police didn't need to read you your Miranda warning. Wah, wah. So the fact that you've taken this class actually means that you can't probably use that defense for those statements. Does that make sense? Sorry about that. I should have told you that up front, that this class was going to ruin your chances of getting away with a perfect crime. So, okay, I have a couple cases that I want to tell you about. I want to tell you about a few cases that are exceptions to the Miranda rule, and then, yeah, okay. So in 1971, in the case Harris v. New York, so Harris, Harris, Harris v. New York. This is the first significant case that begins to kind of chip away at the Miranda rule. And in the Harris case, what the courts established was that if a suspect makes voluntary statements, in the Harris case, they're specifically talking about voluntary statements. They're not talking about statements that are made upon like specific or direct questioning. So if you're sitting in a police interrogation room and they're asking you, did you do it? Did you do it? That's not considered a voluntary statement. That's considered a statement that was coercive or was brought about because of police questioning. But if you're like, hey man, screw her. She stole money from me. I wanted to slap her. Okay, if you made a statement like that while you were being arrested, and then you went to court and said, I absolutely adore her. We have never had harsh words between us. I have always felt nothing but the greatest affection from her. So if you go to court and you say things that are directly opposite of statements that were made voluntarily by you that the police recorded, the police can use your statements to contradict, or the word is called impeach, testimony that came up at court. So if that scenario took place, then those statements could be used to do what is called impeach courtroom testimony. So if you're sitting in court and you're lying and you're saying stuff that is directly conflicting stuff that you said to police earlier voluntarily, they're gonna come in, baby. They're gonna come in. So if it's the defendant's own statements, or if it's the witness's own statements and they're contradictory, then they can be brought in. So that was what Harris v. New York established. Another one, and it's going to sound familiar to you when I say it because it was something we talked about in terms of the search rules, but another exception to the Miranda rule is inevitable discovery. Do you remember us talking about inevitable discovery when we were talking about like the dead body and it being found? Okay. And that if it was going to be inevitably discovered, then the police didn't necessarily need to have a warrant and it couldn't be thrown out. Okay, well the same thing is going to apply with statements. So the case I'm going to talk about here is Nix, N-I-X, v. Williams, and it comes from 1984. What inevitable discovery states, and what the Nix case established, is that if a judge determines that the information provided in the statements would have been discovered even without the information, then those statements are admissible. Think it through. Let it sink in. If the judge determines that the information provided in the statements would have been discovered anyway, then the statements can come in. Then the statements can be used. So in the Nix case, here's a very brief synopsis. The Des Moines Police Department got a suspect to reveal the location of a body and confess to a murder. The prosecution claimed the body would have been found even without the illegally obtained statements. Therefore, in 1984, under the Berger Court, we're not going to talk about Berger, but he was more law and order. In 1984, under the Berger Court, the court established that because the police said we would have found this body eventually, we didn't really need him to tell us where the body was, they could use those statements. So, inevitable discovery can be applied even to witness statements. Got it? Good. And then the last exception to the rule as far as Miranda is concerned is the exception is public safety. Okay? So your statements can't be used against you unless you've been Mirandized, except in this other case. So public safety. And the case that this deals with is also from 1984. And the case is called New York v. Corliss. And you spell Corliss Q-U-A-R-L-E-S. So New York v. Corliss. So public safety, like, how does this have to do with the Miranda rule? And it's kind of interesting. Wait till you hear this. So it says, okay. So police apprehended a suspect in a grocery store and found him with an empty gun holster. Okay? The police, upon finding this suspect, said, "Where's the gun?" And they said this before Mirandizing him. So essentially the police are questioning him. They're asking him, where's the gun? So they see an empty holster, where's the gun? And the suspect told them where the gun was. The suspect told them where the gun was. They went using that information, found the gun, and then used the gun evidence against him to convict him of a crime. What his attorneys argued was that his unmirandized statement that told the police where the gun was led the police directly to a piece of evidence that essentially incriminated their client. And because the statements were unmirandized, that was essentially him testifying against himself, and therefore should not be used based on the Fifth Amendment. What the police argued, what the city of Des Moines argued, was that that gun and the fact that that gun was out there was a public safety issue. They didn't know where the gun was. They didn't know if there was a suspect in the room that had the gun. They didn't know if the gun was lying on the street somewhere, could be picked up by someone that could then use it against the police or another civilian. Because it was a public safety issue, they had to find it expeditiously, and that therefore outweighed the Fifth Amendment rule. So, kind of an interesting piece there. Like, okay, so those are some of the exceptions. So even though the Miranda rule sort of stands as kind of the pillar, I mean, everybody knows it, people talk about it, it's really been weakened over the years. And one of the reasons it's been weakened is because of its popularity. It sort of was murdered essentially by its own popularity, the fact that we have all these cop shows that teach people about it. Now people are considered to have sort of ultimately been pre-warned. The one thing I will say, though, is that immigrant populations and people who are can demonstrate that they aren't familiar with sort of the popular sort of cultural Miranda rights and all that kind of stuff, they have successfully argued that they should have been Mirandized. And in particular, police departments have been instructed to have translators on staff, and oftentimes in places with large immigrant populations, police are actually trained to read Miranda rights in other languages, even languages that they don't speak. So a police officer who doesn't speak Spanish might have been trained in his police training to actually read the Miranda rights in Spanish, so that Spanish-speaking people who might not be as familiar with our laws and with our the cultural prevalence of the Miranda listings, that they then could be Mirandized. Although it's kind of funny, because if they only speak Spanish and then they make a bunch of statements in Spanish, I suppose then if those statements are being recorded and could be played back and translated, then it could be used. Because I was going to say, if the police don't speak Spanish and this guy is saying, I killed her, I killed her, I killed her, in Spanish, and they don't know what that means, then it's sort of a moot point. But I guess if they're recording it, like a lot of cops have little like mounted recorders now, I guess that could work. So, okay, good. Okay, I got to check the time. This is, see how long this is gone. Okay, so we're about an hour in. So what I'm going to do is I'm going to stop this tape. If you guys have time to continue, I'm going to have you continue. If you don't, then I'm just going to say that you should continue and finish up the remainder of it on your own, like over the weekend. But I'll be gone again on Tuesday. So, so I'll post another series of videos probably like on Monday, so you guys can see them. So I'm just not sure, 50 minutes, I don't know how long you guys spent at the beginning of class talking, or you know what you guys need. So I'll do another 15 or 20 minutes on a separate video clip. And also because I'm paranoid that the video isn't going to work and upload, so I'll try to get that rolling now. So okay, good. I'll do that. I'm going to stop now. If you're almost to the end of class and you only have a few minutes left, 5 minutes, something, 10 minutes, well, 10 minutes, I guess you could keep going, but okay. We'll stop here. I guess that's that. I hope that was less awkward than the first time. Okay, yeah. Just tell me it was less awkward.